Lesko from the great state of Arizona. You recognize we're going to miss you, but for your 5 minutes of questioning.
Thank you, Mr. Chair. First, I want to thank the committee chairman, Kathy McMorris-Rogers. She is passionate about this issue, and I have a strong feeling we're going to get this done this year. I also want to thank you, Mr. Chairman, for your work on this issue and others across the aisle as well. As you may expect, whenever we have a data privacy bill in front of us, there's all kinds of people that come out and say there's problems with it, right? And so it's hard for me as a Congress member to know if those are legitimate problems or if there's somebody just trying to kill the bill or, you know, whatever the case may be. And so my questions today alone, I had a couple people tell me some concerns, and I want to see if any of you have any input on it if you think it is a concern. One of them that I heard today was that the preemption language is not strong enough. And so do any of you have any input, and I'm talking about the draft language of the American Privacy Rights Act. Sorry, I didn't clarify that. Do any of you have any input on that?
I think what I would say is that preemption is an area that we just know that in order to get this done, there's going to have to be a compromise. You know, left to our own devices, we would probably say we should let the federal privacy law set a floor and then let states provide additional protections. But understand that that isn't going to be the way that this comes out if we're going to get this passed. So I think what APRA does is try to come up with the right compromise. It sets a preemption, but then it recognizes that there are certain places in which states have particular expertise or history of working where it makes sense for them to continue. So, for example, healthcare. You know, we have a federal privacy law called HIPAA, and we still allow states to legislate in that area. And so we've seen examples where co-jurisdiction between states and federal enforcers can work. And so I think APRA, in general, is moving in the right direction in terms of a compromise.
Anyone else?
The coalition, in its comments, raised a concern. They said that while the general language is very good, that some of the exceptions that still allow state law, you know, for example, on tort law or common law, could be a way to kind of sidestep the preemption and creating that uniform federal standard that Congress is seeking to do.
I would just add, it's very difficult to strike a careful balance on preemption because data touches everything. And there are going to be so many different categories of state laws that involve the use of data, even if they're not necessarily what Congress is trying to regulate in this bill. And you want to be very careful not to break the ability of states to regulate fraudulent practices, regulate other types of harms, civil harms, criminal harms that are happening at the state level that really aren't being anticipated here.
Okay, the next, another concern that I heard was that I believe in the draft of this language, it exempts, or it applies to companies that sell the data. And so one of the concerns was, okay, we're a parent company, we have subsidiaries, and we don't really sell the data, but we share the data with our subsidiaries. And so now we're going to have to live by this standard even though we don't sell the data outside of our subsidiaries. Could anybody comment on that? Okay, well, go ahead.
I could address it or make an attempt. I think in terms of the bad sort of outweighs the good if you let that go. In particular with TikTok, I think it's really important to talk about software developer kits, SDKs. You know, there are third-party tools that can be employed by American applications that can send user data to those companies. So you have, as Mr. Jain said, you have a whole veritable ecosystem of data transfer that's roiling about that if you don't put strictures on that, the companies doing nefarious and noxious things will use those loopholes. So I would say you have to cover those loopholes, plug them, and then you take care of some of the SDK and other data transfer to third-party issues.
Yeah, I think the concern you're talking about here is when you look at parent company and then subsidiary, it goes into a bigger issue that you look at called third and fourth party risk. So the whole ecosystem of the smaller organizations that are taking a look at the data to the larger organizations like we've talked about with TikTok, but making sure that there's the right provision across each line for responsible holding of all of the data, irregardless of the size, where they live in that ecosystem. That's what I think is concerning.
And do you think that in this draft language that it addresses it?
I think it addresses it for the most part. The only thing that raised a caution to me was actually the definition of small business on the dollar cap. And what I mean by that is there's a number, as again we've talked about today, AI is a big concern for us. And as the emergence of AI and generative AI comes up, there's a lot of small organizations that may meet that threshold of small business. They're utilizing data in a very interesting way that should be covered here. So I would look at the definition, I loved it, of 200,000 users, but the dollar cap on it I would be concerned about as we think of the new AI companies that are emerging that are going to be looking for data.
Thank you. The gentlelady's time has expired, and I recognize